Beloved Creator of all that is, let us be ever mindful of our divine connection and inherent power gifted us as beings of light and love. As the year's end nears, the speed of its days defies the thought of there being room to fit much more into it. Like struggling to stuff Thanksgiving and Christmas into a hearth fire stocking. In reflecting on the year and on family and friends comes a flood of gratitude, appreciation for the efforts, the support, and love we share. The compression of time seems as days blurring into bygone weeks, and then year's end, folding into another with its refreshed hopes and aspirations. This quickening of time and aliveness of spirit can be overwhelming and daunting, or enlivening. It is our choice. When we feel daunted or overwhelmed, I suggest it is us feeling the disconnect, as if it is us alone with the task at hand. In contrast, when we are enlivened, it is us feeling the connection to spirit, to prime creator energy coursing through our being. It is the feeling of being energetic and powerful yet humble. It is feeling motivated and passionate, taking action. And it is also allowing oneself to rest, pull in and reflect, meditate, or play. When we are following purpose, motivated by something bigger than ourselves, there is joy, even playfulness. Those of us on this path resonate. Whatever challenges, when effort is matched with gratitude and service to others, grace abides. Let it be so, and so it is. Hello, this is a letter from our court, our Article 3, Amendment 7 Court of Record, Civilian Common Law, to Richard Mulmer, Traffic Court Administrator for Washington County Circuit Court in Hillsboro, Oregon. As our court administrator, I saw your letter to Ron Vroman and need to address and get clarification on what, to our court and to our assembly, is a significant issue. The issue is the same now as the one our court presented to you in our cause number 0501-2024-RV, Notice and Demand and Caveat to Will, regarding two of your case numbers S2024-59 and 24SCO9281. The issue is stated in our Bill of Particulars in that instrument, and it reads as follows. The courts and persons involved in the offices of integrity must provide their proper bona fides. Identify your court and person as Article 7 amended or original with the proper oaths to the proper constitutions that include the laws of nature and of nature's God. Without this documentation, the courts are a nullity with no judges, clerks, administrators, recorders, or employees with proper bona fides such as human resources records of employment, certificates and diplomas, complaints, appointments, and settled or unsettled claims involving those listed here and that may be added after discovery. Your letter included 2 pages of your court's case history regarding Ronald C. Vroman, all caps, or Ronald Charles Vroman, all caps, and in 2 of the cases, Ronald Charles Vroman in upper and lowercase. Are the upper lowercase letters indicative of an Article 7 court, or are they all the same? Or is there no distinction between them? That question remains unanswered. Missing on your list are citations of trespass and for trespass with a firearm. With all this, the issue remains unanswered, that of the Article 7 court in original jurisdiction, as originally established on Oregon since 1859 when it became a common law state of the Union of the several states. If there is any blurring of the lines, it is within the Washington County et al. Court system, when Article 7 became amended unlawfully to our findings. Knowing this, we have yet to find a court, ours is one, where a flesh and blood, mind, body, soul, spirit, man or woman can find remedy. We are aware of recent Supreme Court actions in case you are unfamiliar. A decision has been made on Securities and Exchange Commission versus Jarchese et al., another on the Chevron deference, and as of December 8, 2025, one on Humphrey's Executor versus United States. While all three are of great import to our court, SEC versus Jarchese 603 U.S. 109-2024 is one most pertinent with regard to the issues we address, Ron's probate situation in particular. Knowing what we know, it is unacceptable to be required to appear in a de facto color of law courtroom with a judge, think CRIS, when we know these courts to be illegal or illegitimate. Black's Law Dictionary, 5th edition, page 375. And one that requires an attorney to speak for the living man who is perfectly capable of speaking for himself as jura summa imperii in a simple probate situation. Furthermore, no judge need be involved when we simply need an Article 3 court with Amendment 7 trial by jury in suits of common law, and where the value in this case is 105,000 Federal Reserve notes, which is more than $20 as written in the Constitution. Here, SEC versus Jarchese et al. Is significant as stated in the 7th Amendment, which entitles the defendant to a jury trial. This challenge, in this relative to where Article 7 amended has put us, is that a man cannot stand in a de facto color of law court for remedy for the very reason that there are too many blurred lines, not the least of which is the discrepancy of the all-cap straw man and the upper lowercase living man, both being on paper and across the bar. What is off is denying our court, or any court in original jurisdiction, such as an Article 3 court, is that somehow the state of Oregon, aka all caps state of Oregon, and the county of Washington want to dip their hands into the cookie jar of an 87-year-old retired veteran living on Social Security who gave his house and all he ever laid claim to his younger wife, who just suddenly died and left no plan for him, as it was assumed he would be first to decease the other. I rest. My name is Charlie White. I'm a court administrator for our Oregon Statewide JuralAssembly.org Court of Record. Thank you.
My name is Brandon Wingerter. I am Deputy Clerk of Court on Marion County for the Oregon Statewide Jural Assembly, Article 3, Amendment 7, Civilian Court of Record. Sheriffs, one and all, the ball is in your court. We kicked it into your jurisdiction, which is separate from ours, alas. It really is one team, you and us. It is, or rather should be, one jurisdiction. Your training, probably from childhood, has been put to join the realm of the corporate jurisdiction, which is the entity that pays you to do what you do. You can join our team, that of the people, with a simple turn of a mind switch. A tool to assist in this process is to consider taking a proper oath to the proper Constitution with its original jurisdiction and with the laws of nature and of nature's God, as stated in our unanimous declaration of the 13 United States of America. The last several months, we have posted and made publicly available that we consider a proper oath for the persons in our governance sheriffs are our first effort at insisting on a proper oath. For it is the sheriffs who are in their county position to protect and defend the people from ticketing or sending people to the illegitimate, amended Article 7 courts that should not be, from governance overreach and taxation that takes seniors' equity, their forever home, and all they possess by enforcing convictions. It's like a shift in the mind. It is the recognition of one's allegiance to life and that which is God-given. Rather than criminalizing living God-made beings for a dead corporate entity, our sheriffs are our first protection against governance overreach. Taking a solemn oath is needed for there to be remedy in our authoritative system of governance. Once a sheriff cognizes the importance of the proper oath, they can see themselves as one of the people or one with the people, rather than a corporate entity meant to enforce our compliance to the bidding of the state. Therein is offered greater freedom, cooperation, and peace in all our dealings. Let it be so.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying, and then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.